hope this is bright enough. I'm trying not to wake up the baby. Peace. I want to read you something that my husband wrote. It's pretty lengthy. It's very detailed. It's very specific. Sorry, I'm just sending the live off to a few people. I usually don't go live when there's another more live. I know Kush Day is currently live right now. No disrespect, shout out to Kush Day. He's always pushing the science, history, and law. But I don't get a lot of free time to do this, so I am going to read some of this because it's very important. And this is what it means to be upright, independent, and fearless. So, in the face of adversity, he still takes his stance of an upright, independent, and fearless Moor who cares for his loved ones. And so I will start. Hopefully you can see how he's writing these words, because how he's writing the words are important as well. So I'll go ahead and get started. Peace, Moors. I know it's late, but I appreciate you coming on here. I'm going to start this document that's written by Jamhal Talib Abdullah. He wrote it on December 19th, 2021. It was his 171st day in jail. Again, this is pretty lengthy, so I apologize. But peace, Moors. I hope you enjoy this as much as I did. Again, so proud of him being so upright, independent, and fearless. To whom it may concern, particularly to those who stand for constitutional, free government in accordance to jurisprudence, the actual spirit of law and its letter, not the mere color of law. To those who have a sense of morality and adherence to nature's law and nature's God, which is jurisprudence, divine law, and true religion. By Jamhal Talib Abdullah. A mentally free Moor held as a political prisoner in and at the Billerica House of Corrections, 269 Treble Cove Road, North Billerica, Massachusetts, as of July 3rd, 2021. In re the unlawful detention of my physical body, a memorandum of law. This too will be sent to Superior Court, as have all other documents written by my hand and sent to the clerk of court regarding these unconstitutional charges in their unconstitutional case, to which the clerk of court refuses to properly file and assign or schedule a hearing date so that I may properly argue for my release. Documents that have been filed since July in District Court, Malden, and documents that I've mailed to Superior Court circa November 2021, in addition to the fact that I've made oral and written arguments regarding violations of the Fourth Amendment in both quote-unquote courts, which ipso facto and ipso jure should have already resulted in the dismissal of this case and its merit. I have, in conjunction with the Fourth Amendment claim, have raised a solid, lawfully standing argument based on res judicata and stare decisis, which, according to their oppression, viz. Ipso jure, preclude these allegations, claims, and issues from being raised against me ab initio. Regardless of the acts of those pretend believers in a republic form of government, Article 4, Section 4, United States Constitution, and the pretend believers of justice, I have an obligation to my God Allah to stand up against. injustice, and tyrants who hide behind color of office, color of title, color of authority, and color of law, as well as an obligation to my bloodline to restore the honor and nobility to my ancient Moabite, Moroccan, Moorish ancestors to time immemorial, and my current kin. Quran Surah 8 Ayat 19. If ye sought a judgment, now hath the judgment come unto you, and if ye cease from prosecuting the believers, it will be better for you. But if ye return, we also shall return, and your host will avail you naught. However numerous it be, and know that Allah is with the believers in his guidance. Commonwealth versus Lefkouts. 20 Mass APPCT 513. Mental culpability is required as an element of all crimes. See in General Morissette versus United States 342 U.S. 246 260. United States versus United States. Gypsum Co. 438 U.S. 422 436. Commonwealth v. Mixer 207 Mass 141 142. Intent is a required element in possession. United States versus Holt 464 F3D 101. An act is done knowingly if it is done voluntarily and intentionally, and not because of mistake or accident or for some other innocent reason. The militia and I did not intend to open carry our firearms in Massachusetts. We thought we were in danger, and for self-defense purposes, we kept and bore our arms. Self-defense is innocent and lawful. Finally, the Second Amendment's core purpose further supports the conclusion that the right to bear arms extends to public carry. The court in Heller emphasized that self-defense is the central component of the right itself. 554 U.S. at 559 128 SCT 2783 171 LED 2D 637. This purpose is not limited only to the home, even though the need for self-defense may be most acute there. And then more numbers. Self-defense has to take place wherever the person happens to be, and in some circumstances, a person may be more vulnerable in a public place than in his own home. Mass General Law, Chapter 140, subsection 129 CM, permits the temporary holding, handling, or firing of a firearm where such holding, handling, or firing is for a lawful purpose. Self-defense and self-preservation is a lawful purpose. This is literally Massachusetts' own laws right here. I'm going to read it again. Mass General Law, Chapter 140, subsection 129 CM. Permits the temporary holding, handling, or firing of a firearm where such holding, handling, or firing is for a legal purpose. Self-defense and self-preservation is a legal purpose. Young versus Hawaii 896 F3D 1044. Second Amendment encompasses a right to carry firearms openly in public for self-defense because bear implied such a right. Let me know if you guys can still hear me, because sometimes this audio cuts out on this phone. Brumley versus Commonwealth 413, a whole bunch of numbers. Knowledge of firearms alone does not create reasonable suspicion that officers were in imminent peril. United States versus Robinson 814 F3 201 2016. Constitutional and statutory rights for individuals to bear arms at home and in public applied to all, and courts had obligation to protect those rights. Commonwealth versus Kelly 484 Mass 53. Carrying a weapon is not standing alone and a weapon is not standing alone, an indication that criminal conduct has occurred or is contemplated. Commonwealth versus Miller. All of this. If you want to know any of these specific things, just let me know. We generally presume that criminal liability will not be imposed without some level of mens rea, which means a guilty mind. Gun bans did not change the amount of gun violence. See Miller versus Bonta. Then it can be argued that licensing requirements don't lower gun violence. Even during an outright ban, federal and state statistics show the same amount of violence. If anything, one can argue that making mere possession a crime only increases the amount of gun-regulated arrests and increases the number of gun crime and conviction, although absent an actual injury, loss, criminal agency, criminal act, and absent criminal intent. It is the opinion in the Commonwealth versus Kelly that the mere possession is passive and victimless, that the mere existence of a gun is not a crime, and in Commonwealth versus Young, that unlicensed possession does not create a disregard for the safety or well-being of others and is not dangerous. These titles, these cases that he's referencing, Commonwealth versus Young and Commonwealth versus Kelly. Commonwealth is the Commonwealth of Massachusetts. That's the state of Massachusetts. That's cases that can't come out of Mass about arms. Early colonial history of the Second Amendment did not license the open carry of arms publicly. There was simply a recognition that bearing arms publicly with criminal intent was a crime and thus unlawful. In fact, only black slaves and white abolitionists in opposition to slavery were licensed as a punishment, as others had and maintained the constitutional right to openly and publicly carry their arms unlicensed. See Young versus Hawaii. United States versus Mason. Innocent possession defense can be invoked where the record reveals that 1. The firearm was attained innocently and held with no illicit purpose, and 2. Possession of the firearm was transitory. 1. My rifle was slung in an innocent manner, slung on my non-dominant side with no illicit intent or purpose, and 2. We were transitioning from one state where we could legally possess our arms to another. United States versus Cherry. U.S. Courts of Appeals recognizes the innocent possession defense in situations in which the defendant can establish a justification like necessity or duress. We were under the unlawful and present threat of death or serious bodily injury. It was late. I think that says late. It was something dark and an unidentified vehicle stopped behind us. It could have been a criminal like Dylan Roof or the murders of Ahmaud Arbery or George Floyd. United States versus Mason. There are 2 general requirements that must be satisfied in order for a defendant to successfully invoke the innocent possession defense. The record must reveal that 1. The firearm was attained innocently and held with no illicit purpose, and 2. Possession of the firearm was transitory. The innocent possession defense may arise in a range of factual scenarios. 1. Firearms were obtained after passing a state and federal background check. 2. We were traveling to a state where our acts were not criminal. Also see 10 U.S.C. 246, militia composition and classes. B. The classes of militia are 2. The unorganized militia, which consists of the members of the militia who are not members of the National Guard or the Naval Militia. Commonwealth versus Sweeting, Bailey, December 22, 2021, Supreme Court. This court is very concerned about the disparate impacts automobile stops have on persons of color and the national statistics on the fatalities suffered by such communities at the hands of police officers. All too frequently, the prohibition against facially discriminatory laws, I'm not sure if I'm supposed to say facially or racially discriminatory laws, have been inadequate to address the role played by racism and other invidious I've never heard that word before, classifications in the way facially neutral laws actually are enforced. Mandela versus NTT Data Inc. Most Americans understand that the criminal justice system has quite clear racial biases that create disparate outcomes for Black Americans. Commonwealth versus Evelyn. Long history of race-based policing likely will remain imprinted on the group and individuals' consciousness of African Americans for the foreseeable future, end quote. Commonwealth versus Sweeting. Bailey continued, anyone's dignity can be violated by an unconstitutional search. However, it is no secret that people of color are disproportionate victims of this type of scrutiny. End quote. Utah versus Streif. This disparity is due in part to the powerful racism stereotype that Black men are violent prone. Buck versus Davis. Annotation. The proper identity for people of color, Black Americans and African Americans, all in quotes, as a national identifier is Moor, Moroccan, Moorish, and or Moorish American. See etymonline.com's definition of Negro, and one will find the proper noun Moor as opposed to the adjective Black. In addition, there is a difference between racial discrimination and discrimination based on national origin. See Peoples versus City of Detroit. Here, plaintiffs allege that they were all laid off at the same time because of either race or national origin discrimination. But as is clear, plaintiffs do not allege the same exact claims. Plaintiff Riviera alleges national origin discrimination, and the remaining plaintiffs allege race discrimination. ... Plaintiffs cite no case law, nor do they agree that discrimination claims for national origin are substantially similar to those of racial discrimination claims. In the above cited case, only Rivera, who claimed a nationality, had rights to sue. See Henry Kimball Black's Law Dictionary, 4th edition. Nationality determines one's political status, especially with regards to rights and their enforcement, along with the right to sue. Since Black, African American, and coloreds are not a nation or a race, these persons have been subject to unfair treatment. There is also no legal technical signification to the phrase colored person, which the courts are bound judicially to know. See Posk A versus Dowse. The case law I used in reference to Blacks who are denationalized is used to show, despite our true identity being used, Moors are discriminated against, the subjects of genocide, erroneously called racism. Attached are excerpts from Young versus Hawaii, United States Court of Appeals for the Ninth Circuit, February 12, 2018. Argued and submitted, Honolulu, Hawaii, July 24, 2018. Filed this number, Judge O. Scanlane. You will see there is an unlicensed right to openly carry, keep, possess, and bear arms. You will also see that so-called Blacks and those who oppose slavery were the only ones required to have permission to bear arms publicly via licenses. See also attached definition of license from the Henry Campbell's Law Dictionary and the Christian Black Codes of 1724. Jamhal, Talib, Abdullah Bay, Allah Akbar. For those of you who are joining, I read a whole document that Jamhal wrote, so make sure you go back when the live is over and read it. So he has some things underlined here. This says the unconstitutional convictions, I'm not sure, it says you don't know about. And this is from the Wall Street Journal. And it says, today jury trials are rare. More than 95% of criminal convictions come from guilty pleas. Excuse me. The Supreme Court noted in Lafleur versus Cooper, 2012, that criminal justice today is for the most part a system of pleas, not a system of trials, that imperils Americans' constitutional rights by exposing them to coercive pressure to plead guilty, along with other forms of police and prosecutorial abuse that regularly produce false convictions. To be sure, juries don't always get it right. Jurors are human and fallible. In the past month, also saw a wave of innocent people exonerated after false convictions by juries. These include Kevin Strickland, a black man wrongfully imprisoned in Missouri for more than 40 years after being convicted by an all-white jury, and 2 of the Muslim men convicted in the killing of Malcolm X, potentially as a cover for misconduct by the federal government. It goes on to say that juries are also only as good as the information and guidance they receive. In the rare cases that go to trial, prosecutors too frequently withhold evidence favorable to the defense, manipulate witnesses, and make improper arguments to the jury. He also underlines, yet despite the drawbacks of trial by jury, the alternative, the ad hoc practice called plea bargaining, is far worse. In particular, coercive plea bargaining artificially lowers the cost of obtaining a criminal conviction. Prosecutors can induce defendants to plead guilty by bringing more and more serious charges than are truly warranted, particularly when combined with pretrial detention. Many of these charges would implode spectacularly if tested in the crucible of an adversarial proceeding, and plea bargains protect prosecutors from having to go through hard constitutionally mandated work of building a case for guilt beyond a reasonable doubt. It goes on. Excuse me. This vastly increases the number of prosecutions the government can pursue and facilitates mass incarceration. Plea bargaining can also hide police misconduct from public scrutiny by ensuring that rights-violating officers rarely take the stand. Then there's the horrifying reality that innocent people are sometimes pressured into pleading guilty to crimes. While it is impossible to say exactly how often this happens, scholars place it between 1.6 and 8% of all felony convictions. More jury trials won't solve all the problems in our criminal justice system, but they would bring more misconduct to light and thereby make courts and prosecutions fairer. Potential reforms include curbing the misuse of pretrial detention and mandatory minimum sentences to exert plea leverage. This is the Christian Black Codes of 1724 extensive breakdown. This says the Christian Black Codes of 1724 were initiated during Reconstruction after the Civil War to control blacks after they were emancipated, passed by southern states. Instead of giving blacks the same rights as white people, the codes limited the blacks' freedom severely. They included that blacks had to be in service of a white person, that they could not have congregations together, that they could not speak out, and they could not have weapons. They also included that blacks could not go out without a white supervisor. Thus, blacks had to take on the religion and holidays and gods of their white superiors. These same black codes were said to have been made null and void with the ratification of the 13th Amendment in 1865. Although many southern states adopted black codes to keep former slaves from voting and imposed other restrictions, the 14th and 15th Amendments were to supposedly had eliminated these codes. But as you read them down below, the study of the law of the land in conjunction with religion and politics, you'll discover these codes have been modernized in a disguise, and many are still in effect. So he has Article 12 highlighted. We forbid slaves to carry offensive weapons or heavy sticks under the penalty of being whipped, and having said weapons confiscated for the benefit of the person seizing the same. An exception is made in favor of those slaves who are hunting or are shooting for their masters, who will carry with them a written permission to that effect or are designated by some known mark or badge. Then he also has Article 14. Oh no, that's just a mark on from the copy machine, I guess. He has people who can like print stuff in there for him. So here he has the license, certificate or document itself which gives permission. He has everywhere where it says permission. Without such permission would be illegal. Permission to exercise a certain privilege without the license would not be allowable. Permission from state or sovereign. Revocable certificate of convenience. And then here down at the bottom it says, to license means to confer right or power which does not exist without it. Here he has this section highlighted. This is it looks like a certain case. Yeah, it's this case. I'm not sure what the title is. That's all it says here. Oh, here it is. We begin with Bliss versus Commonwealth. Remember, Commonwealth is Massachusetts. Cited in Heller, a decision, I'm reading it from the phone, especially significant both because it is nearest in time to be the founding era and because the state court assumed, just as Heller does, that the constitutional provision at issue codified a pre-existing right. That's in regards to the Second Amendment. Interpreting Kentucky's Second Amendment analog, providing that the right of the citizens, to bear arms in defense of themselves and the state shall not be questioned. The state's highest court had no doubt that any law restricting the public carry of firearms would import a restraint on the right of the citizens to bear arms. The court then invalidated a restriction on the concealed carry of weapons despite the availability of open carry, reasoning that whatever restrains the, full and complete exercise of the right to bear arms, though not an entire destruction of it, is forbidden by the explicit language of the Constitution. CID. The Bliss Court's strict approach to restraints on the concealed carry of firearms was an outlier of the 19th century. See this case. And Kentucky did later amend its constitution to allow the legislature to pass laws to prevent persons from carrying concealed arms. Nonetheless, the Kentucky Constitutional Convention left untouched the premise in Bliss that the right to bear arms protects open carry. In Tennessee, the state's highest court offered its interpretation of the right to bear arms 11 years after Bliss. See this case. After he was convicted of disturbing the peace by appearing armed in public, Simpson faulted the indictment for failing clearly to require proof of actual violence. The High Court agreed because even assuming that the colonial law did not require proof of actual violence to push colonists for walking with weapons, the Tennessee Constitution completely abrogated it. No such prohibition could survive the state's constitution grant of an express power, secured to all the free citizens of the state to keep and bear arms for their defense without any qualification whatsoever as to their kind or nature. Absent of an act of violence, then Simpson's indictment for merely carrying firearms would allege no crime tolerable to the Constitution of Tennessee. The Alabama Supreme Court joined the chorus 7 years later, interpreting that Alabama's right to bear arms in defense of self-defense and the state. The High Court declared that an Alabaman must be permitted some means of carrying a weapon in public for self-defense. The court ultimately held a restriction on the evil practice of carrying weapons secretly, citing the legislator's power to enact laws in regards to the manner in which arms arms shall be borne, as may be dictated by the safety of the people and the advancement of public morals. But the court made clear where that power of the legislation ran dry. We do not desire to be understood as maintaining that in regulating the manner of bearing arms, the authority of the legislator has no other limit than its own discretion. A statute which, under the pretense of regulating, amounts to a destruction of the right, or which arms to be so borne as to render them wholly useless for the purpose of defense, which would be clearly unconstitutional. The right of the whole people, old and young, men, women, and boys, and not only militia, to keep and bear arms in every description, and not such merely as used by the militia, shall not be infringed, curtailed, or broken upon in the smallest degree. But that so much of it as contains prohibition against bearing arms openly is in conflict with the Constitution and void. But that so much of it as contains a prohibition against bearing arms openly is in conflict with the Constitution and void, ! Because that's exactly what the Commonwealth of Massachusetts is doing right now. Yes and no. There's out of 11, 6 are home, 5 are still incarcerated. And I think you might have missed the document that Jamhal wrote. I just read the document. It was like, 10 pages or something. It was very good, very well written. And this is just supporting documentation to that document that he wrote. So once this live is over, I definitely suggest you go back and listen to it so you can hear what he wrote. Prohibition on concealed carry interfered with no man's right to carry arms in full open view, which places men upon an equally. This is the right guaranteed by the Constitution of the United States. Thus, each of these 19th century cases found instructive by Heller when setting the Second Amendment as an individual right to self-defense is just as instructive when evaluating the application of the right outside the home. While 19th century legislators enjoyed latitude to regulate the manner in which arms shall be borne, no legislature in these states could, under the pretense of regulating, destroy the right to carry firearms in public altogether. Accordingly, even though our court has read these cases to exclude concealed carry from the Second Amendment's protections, the same cases command that the Second Amendment must encompass a right to open carry. He has a little star here, so I'll read that. Yet with Heller on the books, cases in the buzzard's flock furnish us with little instructive value. That's because Heller made clear that the Second Amendment is and always has been an individual right centered on self-defense. It has never been a right only to be exercised in connection with a militia. And bound as the inferior court that we are, we may only assess whether the right to bear arms extends outside of the home, on the understanding that the right is an individual one centered on self-defense. Thus, Heller knocks out the load-bearing bricks in the foundation of cases like Buzzard, for those courts only approved broad limitations on the public carry of weapons because such limitations in no way detracted from the common defense of the state. See this case? The act in question does not, in my judgment, detract anything from the power of the people to defend their free state and the established institutions of the country. In what manner the right to keep and bear these pests of societies, dirks, bowie knives, and the like, can encourage or secure the existence of a militia, and especially of a well-regulated militia, I am not able to divine. The terms dirks, daggers, slug shots, sword, canes, brass knuckles, and bowie knives belong to no military vocabulary. So in regard to the kind of arms referred to in the amendment, it must be held to refer to the weapons of warfare to be used by the militia, reasoning that such cases are sapped of authority by Heller. getting sloppy with the papers. Finally, as did the court in Heller, we turn to the legislative scene following the Civil War. While considering materials that post-date the Bill of Rights by at least 75 years might stretch the term original public meaning, Heller explains that the aftermath of the Civil War, there was an outpouring of discussion of the Second Amendment in Congress and in public discourse as people debated whether and how to secure constitutional rights for the newly free slaves. So although such evidence does not provide much insight into the Second Amendment's original meaning as earlier sources, we nevertheless consider each such evidence somewhat instructive of its meaning. Particularly relevant in this period are the efforts of many southern states to disarm free blacks after the Civil War by adopting black codes, because those who oppressed these injustices frequently stated that they infringed blacks' constitutional rights to keep and bear arms. The various black codes adopted after the Civil War were required blacks to obtain a license before carrying or possessing firearms or Bowie knives. These restrictive gun laws played a part in provoking Republican efforts to get the 14th Amendment passed. Wow. These restrictive gun laws played a part in provoking Republican efforts to get the 14th Amendment passed. The Supreme Court's infamous decision in Dred Scott versus Sanford, rendered 4 years before the first shots were fired at Fort Sumner, would pave the way for such black codes to proliferate after the war. Concurring in part and concurring in the judgment, looking to Dred Scott as necessary context in Civil War era historical analysis, writing for the court, Chief Justice Taney disgracefully dismissed Dred Scott's suit for freedom after concluding that blacks had never been a part of the sovereign people of the United States and therefore could find no recourse in an Article 3 court. Excuse me, my neck is hurting. To hold otherwise, Chief Justice Taney wrote, would have entitled blacks to the privilege and immunities of citizens and thus granted them the rights he felt only whites could enjoy. It would give them the full liberty of speech in public and private upon all subjects upon which its own citizens might speak, to hold public meetings upon public affairs, and to keep and carry arms wherever they went. I hope you can see that. There we go. Perhaps emboldened by Chief Justice Taney's opinion, those who sought to retain the institution of slavery began to eliminate more and more of these basic liberties of slaves, free blacks, and white abolitionists. Let me fix these papers. Somewhat fix those papers. I think I'm almost done. I only feel a handful of papers. So, legislatures to take particularly vicious aim at the rights of free blacks and slaves to speak or to keep and bear arms for their defense. It shall not be lawful for any free person of color in this state to own, use, or carry firearms of any description whatever. This is this case law right here. I'm just gonna try to read the highlighted portions, but if context is needed, then I'll read. The subsequent Civil War was far from perfect. a far from perfect fix to these problems. Those freedmen who had fought the Union Army during the war frequently returned home to the states of the old Confederacy, where the systematic efforts were made to disarm them and other blacks. See also the Freedmen's Bureau Bill, Evening Post, 1866, blah, blah, blah. In South Carolina and Florida, the freedmen are forbidden to wear or keep arms. Emblematic of these efforts was an 1865 law in Mississippi that declared no freedman, free Negro, or mulatto shall keep or carry firearms of any kind or any ammunition, dirk or bowie knife. The law was vigorously enforced in 1866. As an 1866 letter from Rodney, Mississippi, to the Harper's Weekly magazine lamented, the militia of this county have seized every gun and pistol found in the hands of the so-called freedmen. They claim that the statute laws of Mississippi do not recognize the Negro as having any right to carry arms. The labor question at the South Harper Weekly, January 13th, 1866. At 19, seeking help from outside of the state, the letter emphasized that such Mississippi laws did not protect but insisted upon infringing on their liberties. Worse still, without federal enforcement of the inalienable right to keep and bear arms, militias and mobs were tragically successful in waging a campaign of terror against newly freed slaves. (1866). Let me see where we are. Report by the Bureau targeted a Kentucky law that sought to deprive freedmen of their Second Amendment rights. The civil law of Kentucky prohibits the colored man from bearing arms. Their arms are taken from them by the civil authorities. Thus, the right of the people to keep and bear arms, as provided in the Constitution, is infringed. Here it says a joint congressional report decried a Southern California practice of seizing all firearms found in the hands of freedmen. Quoting Joint Commission on Reconstruction, H.R. Rep. Number 30, 39th Congress, First Section, Part 2, page 229, from 1866, proposed circular of whatever that says. The joint report plainly envisioned a right to bear arms outside the home, emphasizing that freedmen in South Carolina need firearms to kill game for substance. But wait, the dissent says we have yet to consider the impact of historical good cause, restrictions on the scope of the Second Amendment right to carry firearms in 34 public. I don't know why I said the 34 part, but that's what it says there. According to the dissent, many states have restricted the public carry of weapons absent good cause to fear injury to person or property. Dissent at 65 through 67. A review of the dissent's evidence compels us to disagree. Many states during the 19th century required people who carried weapons in a disruptive fashion to post a bond or a surety to ensure their good behavior. The revised statutes of the Commonwealth of Massachusetts, 750 subsection 16 Boston, blah blah blah, herein mass acts, and to enforce the surety requirement, such states commonly relied on citizen complaint mechanism. That is, if an arms carrier gave any observer reasonable cause to fear an injury or a breach of the peace, the observer could complain to his local magistrate, who might then require the disruptive carrier to find sureties for keeping the peace, generally for a term not exceeding 6 months. But if the disruptive carrier also had reasonable cause to fear an assault or other injury, such person could be excused from posting sureties despite the complaint. Wow. As an example of the pieces put together, Michigan's 1846 surety law provided that if Any person when armed with an offensive and dangerous weapon without reasonable cause to fear an assault or other injury, he may, on complaint of any person having reasonable cause to fear an injury or breach of peace, be required to find sureties for keeping the peace. The dissent erroneously characterizes surety laws as imposing a severe restriction on the public carry of weapons absent good cause to fear injury, and its analysis of the actual historical evidence is, in a word, cursory, while the dissent focuses on the exception to surety requirements for carriers with a specialized need for self-defense. It ignores the clearly limited scope of the requirement in the first place. Only upon a well-founded complaint that the carrier threatened injury or breach of peace did the good cause exemption come into play by exempting even the accused from the burden of paying sureties. Thus, a showing of a special need did not expand carrying for the responsible. It shrank burdens on carrying by the allegedly reckless. Probably should have read the last sentence, but I'm just going to skip it. Something did complain under such laws would hesitate before treating the requirement so lightly. Were a complainant to bring an unfounded, frivolous, or malicious claim that an arms carrier threatened the public peace, the magistrate would not only dismiss the complaint, but also hold the complainant answerable to the magistrate and the officer for their fees. Wow. And then here it says, Heller saw little weight in historical prohibitions that promised only a small fine and forfeiture of the weapon, or in few cases a very brief stay in a local jail. Certainly an obligation to post a surety fits that mold. Like a small fine, sureties are akin to modern penalties for minor public safety infractions like speeding or jaywalking, which makes them, in the court's view, poor evidence of limits on the Second Amendment scope. Wow. In fact, sureties seem to us even less noteworthy than small fines, since a disruptive carrier, once he posted a... Sorry, I looked away. My baby's stirring up over there, about to wake up. Once he posted a surety, he could go on carrying without criminal penalty. And if he refrained from breaching the peace, of course, his money posted as a surety would be returned in a matter of months. Without regard for the bearer's apparent peacefulness. So I'll start that paragraph. As one would expect, delineating the precise lines within the 14th century English statute was enforced is a difficult task. The phases of the Second Amendment outside the home history versus a historical standards review. In the immediate period after Parliament enacted the statute, it appears that some English constables were ordered to enforce the statute literally and to arrest all those who dared to go armed without regard for the bearer's apparent peacefulness. And then here he highlighted, writing almost 300 years after the statute was enacted, Sergeant William Hawkins, an English legal commentator praised by Blackstone, explained that no weaning, I said weaning, I'm tired, no wearing of arms is within the meaning of this statute, unless it be accompanied with such circumstances as are apt to terrify the people. Then down here, he highlighted the part where it says, Hawkins' narrow interpretation of the statute was in accord with the Court of King's Bench, which clarified that the meaning of the Statute of Northampton was to punish people who go armed, to terrify the king's subjects. Now that I'm almost done reading it, I'm pretty sure Jamhal read this on the live the other day. But sometimes when you hear something being read in a different voice, it hits different for some reason. I'm going to skip over to the little starred portion of this page. As St. George Tucker observed, it would have been strange to apply the United States and English law that presumed any gathering of armed men was treasonous because the right to bear arms is recognized and secured in the American Constitution itself. Noting that the Second Amendment was adopted with some modifications and enlargement from the English Bill of Rights, a view of the Constitution of the United States of America writing that the English right, unlike the Second Amendment, is allowed more or less sparingly according to the circumstances. I'm supposed to read this whole page. I think I'm too tired. I only have 3 pages left. I might as well read it. I'm almost done. Excuse the mess the baby made in the background and the papers. Thus, instead of stitching into the Second Amendment every odd law that hemmed in the rights of the 14th century Englishmen, were considered those English laws only to the extent they inform the original public understanding of the Second Amendment. See Heller, 554 U.S. at 594. By the time of the founding, the right to have arms had become fundamental for English subjects. With our historical inquiry properly framed, the fog encircled the statute of Northampton's true meaning clears away, for the American understanding and implementation of the statute was unambiguously consistent with a robust Second Amendment right to open carry. The extent the framers considered the Statute of Northampton as instructive of the pre-existing right to bear arms, they took a narrow view of its prohibitions. A leading drafter of the Constitution credited Sergeant Hawkins with construed the statute to prohibit arming oneself with dangerous and unusual weapons in such a manner as will naturally diffuse a terror among the people. The First and Second Amendment Supra at 101, American Bench Books for Justices of the Peace echoed Wilson's observation, citing Hawkins. William Rawle, a prominent member of the Pennsylvania Assembly that ratified the Constitution, likewise called Hawkins and wrote that the right to bear arms would not rule out a law prohibiting the carrying of arms abroad by a single individual, attended with circumstances giving observers just reason to fear that he proposes to make an unlawful use of them. Justice Wilson and Williams Rawle reading of the statute is confirmed by various states' weapons carry regulations through the founding era and beyond that were expressly modeled after the Statute of Northampton. See blah blah blah. Several early American states expressly incorporated versions of the Statute of Northampton into their laws. Like the surety laws relied on by the dissent, the state enacted Northampton analogs only sought to regulate disruptive or more specifically terrifying arms carrying. For example, Massachusetts in 1795 enacted a law authorizing justices of the peace to arrest all affrayers, rioters, disturbers, or breakers of the peace, and such as shall ride or go armed offensively, to the fear or terror of the good of the citizens. Emphasis added, prohibiting going armed by night or by day in fears or markets or in other places in terror of the country. The North Carolina Supreme Court offered a definitive interpretation of its Northampton analog in 1843, providing us with the benefit of a more thorough discussion of its elements. State versus Huntley, 25, North Carolina, 3 in red, 418, 1843. After holding that firearms fell within the thought that statute of Northampton would permit only persons of quality, nobility, to carry weapons, see Hawkins, Supra, at 136, subsection 9, such a class bias limitation clearly found no place in the United States. The First and Second Amendments, indeed, neither Justice Wilson nor William Rawle makes any mention of such limitation when citing Hawkins, nor did any other American sources that we have read. I'm going to skip to this last page. Oh, dang, there's two more. I thought it was just, this was the last one. It's to be remembered that the carrying of a gun per se constitutes no offense. For any lawful purpose, either of business or amusement, the citizen is at perfect liberty to carry his gun. It is the wicked purpose and the mischievous result which essentially constitute the crime. He shall not carry about this or any other weapon of death to terrify and alarm, and in such manner as naturally will terrify and alarm a peaceful people. True, the court cited business or amusement instead of self-defense as examples of lawful purposes, but a moment's thought refutes the notion that such a list was exhaustive. Surely a North Carolinian wasn't at liberty to carry his rifle only so long as he twirled it in amusement. Rather, it was the wicked purpose that constituted the crime. We thus disagree with the dissent's view that the carrying of a weapon was itself sufficient to face punishment under a state-enacted Northampton analog. Excuse me, I apologize. Dissent at 65 and 1, as the argument goes, when the drafters of virtually every single state Northampton analog criminalized going armed to the terror in affray of others. The terror or affray language was just purposive, that is, terrorizing the public with the consequence of going armed, so such language was incorporated into statutes, merely to clarify why going armed was itself unlawful. What an odd way it would be to write a criminal statute. To interpret such language as merely purposive is to remove its operative effect, for if going armed was itself unlawful, then clarifying the consequences of going armed adds not an iota of substance to the crime. Of course, where the text of a clause itself indicates that it does not have operative effect, such as whereas clauses in federal legislation or the Constitution's preamble, a court has no license to make it do what it was not designed to do. But it is entirely another endeavor to read language mixed in among operatives elements in a criminal statute as merely purposive. I'm going to skip down where it says, for instance, Maine's 1821 Northampton analog authorizes the arrest of all affrayers, rioters, disturbers, or breakers of the peace, and such shall ride or go armed offensively to the fear or terror of the good citizens of this state, or such others as may utter any menaces or threatening speeches. If riding armed were itself unlawful because it terrorized the good citizens of Maine, it strains the credulity, I've never heard that word either, to suggest that Maine drafters would have felt the need to clarify such reasoning right in the middle of statute's operative provisions. Indeed, why only clarify the consequences of riding armed and no other prohibited conduct? I'm going to skip down to, with that provision in mind, turn to section 30. Where the Delaware Code authorized justices of the peace to punish any slave who shall, without the special permission of his master, go armed with any dangerous weapon, if one had no lawful authority to go armed in the first place. I'm just going to read that again because I skipped some and I feel like the context is important. Where the Delaware Code authorizes justices of the peace to punish any slave who shall, without the special permission of his master, go armed with any dangerous weapon, how might one grant another permission to go armed with any dangerous weapon if one had no lawful authority to go armed in the first place? Or considered Tennessee's 1831 revised statutes, which immediately after providing its standard form, Northampton analog, authorized sheriffs to arrest any person armed with the intention of committing a riot or a fray. The statute laws of the state of Tennessee of a public and general nature, 10 Knoxville, John Haywood and Robert L. Cobb's 1831. Why on earth would Tennessee have so limited a sheriff's authorization to arrest if going armed was itself unlawful? Thus, utterly confused by how we might read a Northampton analog to prohibit all arms carry, we feel the better approach with these statutes is to take them at their word. An American, just like an Englishman, could not go armed offensively to the terror of the people. Such a reasonable restriction on public carry is perfectly consistent with a robust right peacefully to carry a firearm in public. In all, then, the various Northampton analogs found in states across the United States confirm that whatever Northampton banned on those shores of England, the American right to carry common weapons openly for self-defense was not hemmed in by long-standing bans on carrying. And that ends that. I've been reading for a very long time. I think there's one person who's been hanging in since I started, maybe. People came in and came out. Peace, Ashe. So, if you all hopped on this live, I'm about to end it. I definitely suggest that once it's over, I'm going to save it. Peace, amor. I was just telling the Moors, the 4 of you that are here, if you're just joining, I just finished reading after like a whole hour, what it feels like. Thanks for rocking with me. But I just read a document that Jamhal wrote, and it was excellent. So I'm going to end this live, go back and stay at least for the document that he wrote, because I ended up reading the document and the 55 supporting pages. I'm exaggerating with the 55 supporting pages, but that's what it felt like. Peace and love, Moors, Islam. Hope you have a great day. Because it's now 1:52. Dang, it's like, what time over there? It's 2 here, so it has to be 9 p.m., right? Enjoy the sun for me, because it's cold out here. Peace, Moors.